Good day, Crime Talk aficionados. It is Saturday, September 10th, 2022. We have our weekly recap of all the top stories right here in one convenient location. We hope you enjoy it. Go watch some more Crime Talk videos. Have a wonderful day, and we'll see you next time on Crime Talk. First on the docket, the Eliza Fletcher matter. So a violent felon who's been charged with kidnapping missing mother of two, Eliza Fletcher, had appeared in court in connection with her death. Police have charged Cleotha Abston, he's 38, with first-degree murder and first-degree murder in the preparation of kidnapping after abducting the teacher whose body was found in a dumpster. Now, authorities have not yet confirmed Fletcher's cause of death, but they have identified the body as the billionaire heiress, which was found 7 miles from where she was last seen. All right, let's go ahead and just take a look at the affidavit in this particular case. All right, now it's alleged that on Friday, September 2nd, 2022, at approximately 7 a.m., the Memphis police officers responded to a missing person in the 1500 block of Carr Avenue. Richard Fletcher advised that his wife, Eliza Fletcher, went for her regular run around 4 a.m. and had not returned home. She was last seen wearing a pink shirt, purple shorts, and running shoes. At approximately 6:45 a.m., citizens Miles Fortis rode his bike on Central Avenue near Zach H. Curlin Street and found the victim's cell phone as well as a pair of Champion Slide sandals laying in the street in the same area. Now, Fortis turned these items over to a family member of the victim, who in turn turned them over to investigators. Thereafter, investigators located video surveillance near 3876 Central Avenue that showed a black GMC Terrain passing and then waiting for the victim to run by. A male exited the black GMC Terrain, ran aggressively towards the victim, and then forced the victim, Eliza Fletcher, into the passenger side of the vehicle. During this abduction, there appears to be a struggle. The Champion Slide sandals were found in the same area. The vehicle then sat in the parking lot with the victim inside for approximately 4 minutes before it drove off. The vehicle had noticeable damage to the back passenger taillight area. Additionally, approximately 24 minutes before the abduction, surveillance footage captured the same vehicle in the area and captured a partial plate of DX. On Friday, September 2nd, 2022, the Champion Slide sandals were sent to TBI for DNA testing. Thereafter, investigators developed Cleo Abston Henderson as a person of interest in the investigation. DNA found on the shoes matched DNA for Cleotha Abston Henderson in the CODIS database. This led investigators to seek to confirm the whereabouts of Cleotha Abston before, during, and after the abduction. Investigators were able to recover surveillance footage of Cleotha Abston wearing the same Champion Slide sandals a day before the abduction. The footage was obtained from the 1080 North Germantown Parkway Malco Theater and was collected by Sergeant Dobbins. Cleotha Abston was found to reside in the 5700 block of Waterstone Oak Way. This location has active utilities in the name of Gwendolyn Brown. Researching law enforcement databases revealed that Gwendolyn Brown has a black 2013 GMC Terrain with license plates BDX7952, and then it lists a vehicle identification number that is registered to her. Investigators also located a police report dated September 1st of 2022 that listed the address in the 5700 block of Waterstone Oak Way for Cleotha Abston. Sergeant Payne and Sergeant Barrett then interviewed the owner of the Majesty Cleaning Services, Marilyn Pickens, who verified that she employed Cleotha Abston and he drives the GMC Terrain, and that his telephone number was 901-825-2028. Investigators obtained cellular phone records for that number, and analysis determined that the cellular device associated with that number was near 3876 Central Avenue during the time Eliza Fletcher was seen being forced into the black GMC Terrain. On September 3rd, 2022, at approximately 10:45 a.m., the 2013 GMC Terrain with license plates BDX 7952 was located by members of the United States Marshals Two River Violent Fugitive Task Force. The vehicle was backed into a parking spot in the parking lot in the 5700 block of Waterstone Oak Way and was confirmed to be the vehicle by the license plate number and by the noticeable damage to the rear passenger side taillight. The damage was captured in the video of the abduction and the partial plate identification of surveillance footage. Further, members of the United States Marshal Service Two Rivers Violent Fugitive Task Force observed a male subject matching the physical description of Cleotha Abston standing in the doorway in the 5700 block of Waterstone Oak Way. Officers then detained Cleotha Abston at his location while he occupied the GMC Terrain. When officers stopped Cleotha Abston, he attempted to flee but was taken into custody. Investigators interviewed Chantel Anthony, and she stated that after the abduction at approximately 0750 hours, she saw Cleotha Abston at the home of Mario Abston in the 1700 block of South Orland Street. This is not the house that Cleotha Abston lives. She stated that she saw Cleotha Abston cleaning the interior of the GMC Terrain with floor cleaner and stated that he was behaving oddly. This was later confirmed by Mario Abston, Cleotha Abston's brother, who stated that he too saw Cleotha Abston cleaning the interior of the car with floor cleaner. Chantel Anthony and Mario Abston saw Cleotha Abston washing his clothes in the sink of the house. He stated that it appears that Cleotha Abston was acting very strange. Cleotha Abston declined to provide investigators with the location of the victim, as the abduction was violent, with, as captured on video, the suspect waiting for, then rushing towards the victim, then forcing the victim into the vehicle where she was confined and removed and continues to be missing. It is believed and supported by the facts and physical evidence that she suffered serious bodily injury. Further, it is probable and apparent from the witness statements that these injuries left evidence, examples blood, in the vehicle that the defendant cleaned. And then it is signed. So, first of all, good affidavit, nice, short, and brief. Obviously, this was written to arrest and detain Mr. Cleotha Abston prior to the body being recovered. But a good affidavit, literally no more than a page and a half long, cuts to the chase. You didn't spend 15 pages identifying the statutes that you want to investigate. All right, so let's continue with this story because there's a lot of breaking news with it. So this comes as the former FBI investigator revealed that Abston's first kidnapping victim, Memphis attorney Kemper Durland, worked in the same law firm as Fletcher's uncle, Michael Kinney. This former FBI agent said, "I think this is a very significant clue, and I'm sure that the FBI, the United States Marshals, and the Tennessee Bureau of Investigation are looking closely into this relationship, if there's any." I think this more appears to be just a random act of senseless violence by a predator, who obviously will give that presumption of innocence. You know how that works. Appears to be he was looking for her. Needless to say, Fletcher's families are understood to have attended the short court appearance, which was adjourned until another hearing set for September 7th. He appeared in court wearing a mask and green-issued prison uniform, swaying back and forth, looking towards the victim's family before telling the court in an affidavit that he cannot afford a lawyer or make bond. Now, Abston did not speak during the short 15-minute hearing and was led away by officers with his hands cuffed behind his back. Now, the ultra runner vanished while out on a jog around 4:30 a.m. on Friday, sparking a 4-day-long hunt, which led officers to several wooded areas across Memphis. The area where the body was found is just 100 yards from the Longview Gardens apartment complex where Abston's brother Mario resides. A van believed to belong to the medical examiner's unit left the scene 6 hours after the remains were found, and it is thought to have been transporting the body. Mr. Abston, who's now 38, has had previous run-in with the law, as noted earlier, and he was only 16 when he and an accomplice kidnapped this coworker, threw him into his own trunk, and tried to force him to withdraw money at a gas station ATM back in 2000. Now, Abston spent 22 years in prison for the crime, and 2 years after his early release in 2020, he is now back in custody for Miss Fletcher's suspected kidnapping and murder. In his victim impact statement of his previous victim, who died in 2013, said he feared for his life during the kidnapping when he was rescued by nearby Memphis Housing Authority guard who heard his screams for help. It's quite likely that he would have been killed had he not escaped. Now, according to the impact statement, the lawyer was alarmed by the teenager's lengthy rap sheet that began when he was just 12 years old, which included charges for theft, aggravated assault, and rape. Needless to say, a lot of people were upset that this individual was released from prison early because, well, if he hadn't been released early, he'd still be in prison. And guess what? In this particular case, perhaps there would not be a deceased woman who had been kidnapped. Just saying, right? Funny how that works, isn't it, ladies and gentlemen? As some people have stated out there, that could have been anybody out jogging that morning, a student, and to find out that this guy was just released 2 years ago for another abduction and gets out and does the exact same thing. Another neighbor around there said, yeah, it makes me sick. She was out yesterday offering to aid in the search when police and a bloodhound were in the area within a couple hundred yards of the body. Now, the violent felon, and we're going to find out more information about this gentleman as things come out, obviously is accused of kidnapping and killing the billionaire heiress Eliza, had stalked the area she went missing from while jogging for almost 30 minutes before the abduction. A neighbor of Mario Abston's has stated that she had seen the suspect at his brother's house nearly every day for the last month. And when Mr. Cleo Abston was in fact charged with the aggravated kidnapping and tampering with evidence following Fletcher's disappearance, officers stated that they have footage of the vehicle used in the kidnapping in the same area 24 minutes before the mother of two was taken at 4:20 a.m. in Memphis, Tennessee. Surveillance footage, which has not been released, apparently shows a man aggressively moving towards Miss Fletcher and forcing her into the vehicle's passenger side. The pair struggled, then the car sat in a parking lot for about 4 minutes with Fletcher inside before driving off, as we stated in the affidavit. Mr. Abston has new charges against him that include identity theft, theft of property, and fraudulent/use of illegal possession of credit and debit cards. Shortly before the discovery of the remains were found, it emerged that Abston has priors for obviously the aggravated assault with a weapon, and sexual assault, all the while he was a juvenile, according to some reports. Mr. Abston's bail has been set at $500,000, and it's understood that he is refusing to cooperate with police. Now, police believe that Ms. Fletcher, a kindergarten teacher, suffered serious injury at the hands of Mr. Abston, and that blood was obviously left in the vehicle. His brother, Mario Abston, was arrested on Saturday after officers searched his home when his brother was spotted acting suspiciously by neighbors. Officers found a semi-automatic handgun, a scale, and a bag of heroin and fentanyl. He was charged with being a felon in possession of a firearm during the commission of a dangerous felony, and possession of controlled substances. Abston apparently told the police that his brother had been cleaning the interior of his GMC Terrain floor cleaner and washed his clothes in the sink of the house. We'll obviously continue to follow this story. Obviously, it doesn't seem like a whodunit at this point since the alleged kidnapping is on video. The question is, what else is going to be found on video as well? But it really strikes to the heart of the matter. Past performance is indicative of future results. Here you got a guy went to prison for basically doing the exact same thing, gets out and does the exact same thing. Sometimes you have to wonder. Obviously, yes, the prison sentence is supposed to punish and also hopefully rehabilitate, but sometimes that does not actually happen much. And some people, frankly, do not want the help at all. So it's a tragic case, but I'm telling you, ladies and gentlemen, be careful out there. This is a case that literally could happen to anyone. She was out at 4 a.m. running because she competes in ultra marathons, for goodness sakes. It can happen to anyone. Be careful. Next on the docket, are the district attorneys playing games in the Lori Vallow matter as far as turning over discovery? Well, Lori Vallow's attorneys are asking for the court to tell the district attorney to turn documents over. And what do Vallow's attorneys want? They assert in their pleadings that a written request for discovery was made originally back on April 18th of 2022, which included to provide any statements made by co-defendants, any witnesses' statements, witness lists, and a list of witnesses who reside in Arizona, Utah, and Texas, and elsewhere. And apparently some of these witnesses have been in regular contact with the prosecutors or their agents, i.e. the police. It is alleged that these statements have not been disclosed by the prosecution. Is this a discovery violation? Well, normally what takes place is if the defense thinks that something has not been turned over, they ask the prosecutor. The prosecutor then says, oh yeah, hey, let me get that for you. Or they'll say, pound sand, we don't have it, or it's not within my care, custody, and control. And then you say, fine, I'll go get it. But if it's in the possession of the district attorney or the agents that report directly to the district attorney has to go and get it. It's their obligation under the law. Now, the defense is requesting also copies of any immunity agreements that the state has offered to any witness. What is that? Well, that's anything regarding any promises of leniency. We're not going to prosecute you. Hey, if we prosecute you, we're going to give you a really good deal. That all goes under what they call Rule 608 for cross-examination, which is basically any bias, motive to fabricate whatsoever. It all comes in for people to change their stories, to maybe exaggerate a little bit, maybe have a little bit of a faded memory. Could it be because the memory is just faded, or is it because they forgot that particular detail because it doesn't particularly help the defense? Those things need to be turned over. And the defense says, hey, Mr. District Attorney, we also need a good faith witness list. Now, apparently the state has endorsed 104 witnesses, but they've also failed to include any address or contact information. Now, I don't practice law in Idaho, but normally the information that needs to be turned over on a witness list is the name of the witness and their address or telephone number so that you can actually go and interview them. I know it seems like a radical concept, right? It's not. And only if there is some good cause, like for some sort of tampering of witnesses or something, or danger to the witness, would the address be withheld, and it would usually go to the care of the district attorney. And then the district attorney would help you coordinate the address and contact and see if this witness wants to be interviewed by the defense. Once again, here we are 4 months from trial. Why has this not been turned over? And I've mentioned this before. The prosecution has to turn everything over to the defense, good, bad, or ugly for the prosecution's case. Why are these statements, assuming they exist, not being turned over? Now, given the length of time this case has been going on, you would think the whole case had been indexed multiple times, years into this case, and the defense is saying statements are not in our possession. 4 months from trial, ladies and gentlemen. Now, whether this is an honest mistake or playing games, I'm not saying they are. Either way, but come on, prosecution. Now, remember, if the court finds you didn't turn these statements over, and if worse, the court finds that it was bad faith that you didn't turn them over after you possessed them because you thought of some theory why you wouldn't have to turn them over, guess what? Those witnesses could be prohibited from testifying at trial as a sanction for the government's conduct. Or possibly the defense would have to ask for a continuance. And I'm really starting to think maybe it's the prosecution that wants a continuance in this particular case. I've said this before and I'll say it again. Always fear a prosecutor who willingly says, I will give the defense whatever I have, whatever they want. The DAs who play discovery games, it comes back to bite them in the end. So, is the DA playing the games? Honest mistake? Or maybe they're just in over their head? Let me know what you think. Another motion that the defense just recently filed is the defense for Lori Vallow is asking for a bill of particulars. What's a bill of particulars? Well, that's basically as it relates to the whole issue regarding the motion that was apparently argued, since it was done in secrecy, about the whole issue of the charging documents. The defense for Lori Vallow has basically said, hey, Judge, if you're not going to make them go back and charge these charges correctly, we're going to make this record and ask for a bill of particulars and say, Judge, there are multiple theories of prosecution that could be done here, and frankly, we don't know which one to prepare for. And the way it's charged right now, the prosecution could change their theory of prosecution mid-trial if things don't go their particular way. So the defense is saying, you need to give us this information now. And the essence of the bill of particulars are that really there are 3 separate allegations of murder which are alleged to have occurred on 3 separate dates. The conspiracy to commit those crimes were alleged to have occurred over a 2-year period. And there are allegations of grand theft and conspiracy to commit grand theft. There are at least 2 co-conspirators, one of which has been named in the indictment posthumously. And there are known unnamed co-conspirators as well as unknown co-conspirators according to the indictment. Third, the discovery in this case is voluminous, to say the least, and discovery is still ongoing. As of the date of this motion, defense has nearly 5 terabytes of electronic material. And they give an example and say, hey, Judge, just to give the court a flavor of the amount of discovery, a terabyte is approximately 1 trillion bytes of information and could store 1,000 copies of the Encyclopedia Britannica. And much of the discovery has been gathered over several years, and the defense is in the position of sorting through all the discovery, which the prosecution has had in some instances for years. And a bill of particulars would narrow down the possible alternative theories that Ms. Vallow would be required to defend against. They also cite that Ms. Vallow has been incarcerated for over 2 years under conditions that make it difficult to review the technical materials in discovery, and taken together, the factors create a perfect storm of difficulties in preparing for trial. Without a bill of particulars identifying and defining the issues laid out below that the government actually intends to assert at trial, the defense will face an impossible task of preparing to defend against dozens of potential scenarios. Now, yes, granted, the prosecution does not have to tell them exactly what they're going to present as evidence, but guess what? A good prosecutor is going to say, this is what my evidence is going to be. Here it is. Let's narrow this down. Let's do this so that we don't have to have a continuance. Because you know what that motion for bill of particulars is saying, Judge, it's coming down the pike. Judge, I need a continuance. I understand my client won't or doesn't want to waive speedy trial, and I'm filing this motion over her objection because I have a duty of ethics that makes sure that I provide effective assistance of counsel. And if the attorneys haven't been able to review all of the discovery in the case and to analyze it, to engage in motions practice, one could argue that they were not effective. See where I'm going with this, ladies and gentlemen? Like I said, you can't blame Mr. Archibald and his co-counsel. They just got on the case, okay? And he doesn't seem like the kind of guy that plays a lot of games, but he is laying the groundwork for, hey, Judge, I'm going to be ineffective if you don't help me by having the prosecution lay out a little more specificity what they intend to do at trial. So just saying, good prosecutor will tell you anything you want to know. And finally, the court has set a motions hearing for September 15th, 2022 at 9 a.m. Now, it's uncertain what this motions hearing will be about. Perhaps the motion for a bill of particulars. Unclear whether it's going to be made to the public or if somehow it will, by chance, be closed yet again, because we don't want to cause any embarrassment to anyone during the proceedings. And, we don't want to prevent either side from receiving a fair trial by having a closed and secret hearing. Just saying, something to think about. Let's keep it open to the public. Let's put it out there on the court's channel so we can all watch it. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Lori Vallow news. Now, remember Lori Hellis? She's been on the program. We can link to our conversation with her, but she has kept the heat to Judge Boyce to do the right thing. Now, Judge Boyce, appears to have done everything he can to delay what ultimately he has decided to do. First, he said Lori Hellis has no standing whatsoever. Then he refused to accept her filings because her P.O. box wasn't sufficient. Well, now he finally says, after you've detailed specifically what hearing and what motions you would like to have unsealed, and Lori Hellis has listed all of the hearings that were sealed from and withheld from the public because it could be a threat to either party receiving a fair trial. Hogwash, okay? The facts are what they are. The only thing that matters is what's presented in court. Bottom line, okay? So the judge has finally set a hearing based upon Lori Hellis's motions, and that hearing is now going to be set for October 13th at 9 a.m. Schedule your calendars. Assuming it's somehow not made sealed or private and keep the public out, we will bring it to you for sure because this is very, very important. Now, what the court did is basically notice a couple of other people that may be designated as persons of interest, so to speak, that may have an interest in keeping the proceedings private. One, Mark Means. That's right. Mark Means may be back. Who knows? Maybe he has no objection to anything being released into the public. The State of Idaho Department of Health and Welfare for basically their motions or their filings that they've made regarding the competency proceedings as it relates to Lori Vallow. And then John Pryor, who is ultimately, obviously, the attorney for Chad Daybell, Lori Vallow's alleged husband. So we're finally going to have that hearing. Now, in some other news, let's just talk about this quickly. The judge has denied the defense's request for the district attorney to reconvene a grand jury and go back to the grand jury and basically fix what the defense believes to be charging errors. The judge has basically said in his order, hey, close enough for government work. Hey, the prosecution in these counts that they believe that there are defects charge a conspiracy. And so if there's more than one predicate act basically for the conspiracy, close enough, we'll sort it out in jury instructions and definitions and things like that. But the charge is conspiracy. Well, is it a conspiracy to commit murder or is it a conspiracy to commit the theft? So a little confusing, probably a little too far in the weeds for most people, just don't care, but it does matter. But that explains why the defense recently filed a motion for a bill of particulars, basically requesting the same thing, saying, hey, we're unclear as to exactly what took place because there appears to be multiple crimes and dates charged in this overall conspiracy. Can you provide me with a little more information, given the fact that there's like 8 terabytes of discovery in this particular case? So it moves on. So the bottom line is the defense request is denied, close enough for government's work, and we'll just move on. We will see what takes place with the request made by Lori Hellis. I'm assuming at that hearing that is now set for October 15th, Lori Hellis will actually get to argue her motion. As a citizen, not as an intervener, semantics are very important. Form over substance is really important. I'm being sarcastic there, ladies and gentlemen, okay? Because this judge has done everything he can to keep these matters sealed. And I'm telling you, I cannot think of a single time, and I've done some of the cases worst of the worst, homicides, sexual assault cases, kidnapping, sexual assaults, the worst of the worst. And not once has the judge said, "Oh, this could be rather sensitive. Let's go ahead and close the hearing so that people that hear it somehow could find it offensive, or maybe it will prejudice the prosecution or the defense." How is the facts going to prejudice one side or the other? I don't get it. I think the judge has made a big mistake on this, and I'm not sure why the defense has not been objecting and saying, no, we want an open proceedings, regardless of how embarrassing it is, because, we don't do that here in America by having closed proceedings and the results already made before everybody shows up to the hearing. What is this, some sort of little star chamber or something? I just don't get it. Hopefully we're going to fix this issue, and hopefully things will be in the public eye for the world to see.